The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampala, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance pertinent thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP Law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
In Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
The next one is with respect to estate, alright? Gifts, alright? Bequest, devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. The other one is inter vivos. Now, incidentally, I just got reminded that, well, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
You can answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it should be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the other way.
Importante, again, sequential, you may skip, but make sure that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. Make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations, no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my note of my booklet, because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, kung sa law school, nagagawa yun dati, puro arrows, you try to direct your professor on where to do.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like, for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or, for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand, and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading initiatory pleading, which is made and settled. Integral part thereof would be what? Judicial agreements.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villasis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our programs. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer for today is currently serving as the administrator of the Intramuros Administration, an agency attached to the Philippines Department of Tourism that is responsible for the orderly administration and development of the historic district of Intramuros. Under his term, he is leading the urban regeneration of the old city of Manila through proper conservation planning, culture, arts, heritage, and sustainable tourism initiatives. This effort has led to record increases in visitors' arrivals, income from commercial operations, infrastructure, urban regeneration and planning initiatives, and community stakeholder partnerships. He has also served in various capacities in the Tourism Infrastructure and Enterprise Zone Authority and rose from the rank to eventually being appointed as its Chief Operating Officer, and also served in the Office of the Presidential Advisor for Political Affairs, the Senate of the Republic of the Philippines, and the Department of Health as well. A graduate of the University of Santo Tomas, with the following degrees: Master of Laws, with Latin Honors Cum Laude, Bachelor of Laws and Bachelor of Arts, major in Literature. He is also a law professor in the Adamson University's College of Law and Bulacan State University's College of Law. He teaches commercial law review and other subjects related to it as well, and also political law review. Ladies and gentlemen, please welcome Professor Guillermo Biasido.
Hey everyone, my name is Guillermo Biasido and welcome to the free online lecture series brought to you by the Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device of your choice. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this opportunity of learning now. Like the Facebook page and share this FB Live session. Host a watch party and tag your friends as well.
Villasis Law Center.
To learn more of how you may learn more of this session. Together, you will learn this all at the comfort of your homes. Before we start, please comment VLC if you you're hearing me clearly. So let us start. Allow me to share my screen. So the task given for me today is to give a short discourse on developments in special commercial laws and also to update you on the latest developments pertaining to certain laws related to special commercial laws. Now, for purposes of today's discussion, I would like to outline the discussion into 2 points. First, I would like to give you significant developments in legislation that has impact on special commercial laws. Then I will move on to significant developments in jurisprudence and other issuances that you will find useful in your review for the bar examination. Okay, so before we start, kindly comment VLC in the comment box of the Facebook page. So, in terms of legislation, the significant development there will be the passage of what we refer to as the Personal Property Security Act, and that is basically Republic Act 11057 and the implementing rules and regulations that were subsequently promulgated after the passage of the law. Now, when we speak of Republic Act 11057, let me just give the context that it was signed into law on August 17, 2018, and the implementing rules and regulations were uploaded into the official gazette last November 2019. So in effect, with the promulgation of the implementing rules and regulations, we are now implementing fully the Personal Property Security Act. Now, the PPSA was passed by Congress basically with one principal objective, and that is to promote economic activity by increasing access of micro, small, and medium enterprises by establishing a more unified and modern legal framework for securing obligations with personal property. So later, I will give to you what the context was prior to the passage of the Personal Property Security Act and what are the significant developments introduced by the PPSA. Now, before the Personal Property Security Act was enacted into law by Congress in 2018, what was the situation? Before the PPSA, the creation of a valid security interest over personal property under Philippine law was governed by different laws, principally by the Civil Code and the Chattel Mortgage Law. Now, significantly as well, in terms of what the situation was, with the PPSA passage in 2018 and the implementing rules and regulations in November 2019, under the PPSA rules, all security interests created from 2019 to the PPSA's full implementation when the registry established and operational, referring to what the PPSA IRR refers to as the transitional period, will now be governed by the PPSA, except that the registration will be in accordance still with the chattel mortgage law until the registry is fully established by the Land Registration Authority. And once the registry, the central registry has been established, the creation of a valid security interest over personal property under Philippine law will now be entirely governed by the PPSA and the PPSA rules. Now, again, what was the situation before the passage of the PPSA? Under old rules, banks and other lenders preferred traditional collateral, definitely, such as land, buildings, and other immovable property, because basically the financial institution prefer registered title as well as the property's type, size, and movable nature made it more easier to enforce the security that's the subject of the contractual obligation. And movable collateral, based on the assessment of the financial institutions, were perceived to be more
Villasis Law
risky
Center.
than immovable collateral. And this, of course, definitely made it difficult for micro, small, and medium enterprises to obtain loans from a credible financial institution, since they have no immovable property among their assets. So this was principally one major objective that the PPSA wanted to resolve. Again, to allow micro, small, and medium enterprises to have access to credit facilities being offered by by these financial institutions. Now, with the PPSA now being enforced, okay, it mandated the Land Registration Authority to create a centralized registry where all notice of security interest and liens and personal property may be registered. Proper reference may be made to Chapter 5 of the PPSA law. Now, aside from that, we said One major objective is to to ensure that there is already a uniform set of rules that will apply to security, interest, and lenience over personal property. The expectation, of course, that with the enforcement of all of these uniform rules, people will have more access to facilities being offered by financial institutions. Okay? Now, I hope you're enjoying so far this webinar. Kindly type DLC in the chat box. That is, you may find the chat box as well. Moving forward, the PPSA also expanded what we refer to as registrable collateral. Under the PPSA now, registrable or collateral, which basically implies this can also be subject of security agreements, include deposit accounts, receivables, checks, and other negotiable instruments, shares of stock, store inventory equipment, livestock, motor vehicles, and even intellectual property rights are already included in assets that can be the subject of security agreements between the parties. However, and this is very clear under the provisions of the PPSA, it does not cover aircraft and ships, which are covered by other special laws as well. Now, one significant development introduced by the PPSA as well is that it now includes and allows the use of future property as collateral, provided that the security interest is not created and unless the borrower acquires rights in it or the power to recover it. Proper reference to that would be Section 5, subparagraph B of the PPSA law. Why is this significant? The situation was prior to the PPSA, a borrower cannot pledge or mortgage property that he does not own, with the objective of increasing capital access to micro, small, and medium enterprises. Significantly, the PPSA introduced and made it possible already to allow future property to be the subject of security contracts and agreements. But you will note later, and I will show to you, that there are significant guidelines as well on how future property can be the subject of any security interest. Now, under the PPSA as well, pledge, chattel, or mortgage of a movable collateral will differ in terms of formalities as to creation, protection, and registration and enforcement. And how does the implementing rules and regulations provide for this context? You have to consider first the type of property in terms of whether it's tangible or intangible. And later, we will show you as well the significant provisions of the IRR in conjunction as well with the applicable provision of the Republic Act. Okay, so we will make a comparison in terms of how this is being enforced in the implementing rules and regulations as well. Now, an example will be in pledge delivery of the thing pledge is necessary. And this is even provided under the Civil Code. For its validity, while in chattel mortgage, delivery is not necessary. So again, you will see that there are significant rules already introduced in terms of how security interests may be constituted depending on what type of personal property is involved. Okay. Now, while you're watching, please tag a friend, or you may have a watch party as well, in order for everyone to enjoy this session further. As I was saying a while ago, under the PPSA now, there are specific rules and formalities as to creation, perfection, registration, and enforcement. And these were all simplified and harmonized already. And in implementing rules and regulations, it is clearly provided on how to constitute a security interest. A signed written contract is enough to create a security interest. But there are formal requirements as well. And these are all provided in the law itself and in the implementing rules and regulations. Now, under the PPSA and the implementing rules and regulations, there are grounds, okay, or there are also guidelines with respect to how we should construe the perfection of that security contract or agreement. And this is consistent as well with the intent and the principal objective set by the law to create a central registry. So that means, and clearly we will show you later as well, that there is a requirement that there must be proper notice to the LRA in terms of how this security interest will be properly enforced. Now, with respect to possession, that is also a requirement in terms of how this will be properly done. But again, this will all depend on what kind of property or personal property is the subject of the security interest agreement. Now, we've already said, right, that there are already set of formal requirements in terms of ensuring the perfection and enforceability of security interest in movable property. And the enforcement of these uniform rules are basically intended to ensure ease of doing as well the execution and enforcement of the security agreement that the parties will be legally be bounded to and will be subsequently enforced as well. Okay, so proper reference in terms of the formalities may be referred to in Section 12 of the PPSA law. Now, with the passage of the PPSA, there were a number of laws that were amended, modified, okay, in terms of how the PPSA will now be properly enforced as well. So let me go through a rundown of the laws that have been subsequently affected with the passage of the PPSA law. These laws include the following. They include even presidential decrees that were issued long before, and other issuance or portions which are deemed to be inconsistent already with the framework set by the PPSA. Okay, so these laws were either repealed, modified, or amended accordingly. So one of them is sections 1 to 16 of Commonwealth Act number 1508, otherwise known as the Chattel Mortgage Law. So in terms of the chattel mortgage law, please make reference to the fact that sections 1 to 6 has already been 16. Sections 1 to 16 of Act number 1508 has been subsequently repealed, amended, or modified due to its consistency already with the Personal Property Security Act. Okay. Articles 2085, 2123, okay, 2127, 2140 to 2141, Articles 2241, 2243, and including Articles 2246 to 2247, has been subsequently affected as well by the Personal Property Security Act. So all of these articles are covered by the Civil Code, but it's been subsequently affected with the new rules set by the PPSA and its implementing rules and regulations. So please note particularly
Law Center.
and kindly note as well in your code, the codal that you are in possession of, that all of these articles have been subsequently affected already by the Personal Property Security Act. So I hope you are learning so far from this session, and do participate actively as well by saying whether by typing DLC to ensure that there's active engagement between us in this conversation. Now, another significant provision of the law that has been subsequently affected is Section 13 of Republic Act number 5980, okay, or otherwise known as the Financing Company Act 1998. Okay, so please note, and this is significant in your discussions of when you do cover already commercial law review, that this significant portion of the Financing Company Act has been subsequently amended, repealed, or modified accordingly by the Personal Property Security Act. Okay. Now, let me move forward as well, because there are a number of laws basically that were also affected by the passage of the Personal Property Security Act. Now, proper reference as well must be made to sections 114 and 116 of Presidential Number 1529, otherwise known as the Property Registration Decree. All of these provisions under the Property Registration Decree has been subsequently affected as well by the passage of the Personal Property Security Act. Okay. Now, other than that, please make reference as well to Section 10 of the same presidential decree, insofar as it is considered to be inconsistent with the law already. And finally, Section 5, subparagraph E of the Land Transportation and Traffic Code has been affected as well by the passage of the Personal Property Security Act. Now, in terms of the Personal Property Security Act, we should remember also as well that while the intent is to expand access to credit facilities being offered by financial institutions, okay, to micro, small, and medium enterprises, we must remember that there are also limitations in terms of its scope. So, what will now be the scope and what will be the limitation of the PPSA? In terms of scope, let us, at least I would like to reiterate, that the PPSA applies to all transactions of any form that secures an obligation with movable collateral as stated in Section 4. So, this is the general rule in terms of its scope and coverage. All transactions of any form that secures an obligation with movable collateral. While this is the general rule, of course, no, there are always exceptions to the general rule. Okay? And what are the exceptions? And this I believe I've stated earlier. There are only two exceptions with respect to the scope of the Personal Property Security Act. Okay? Interest and aircraft, subject to Republic Act 9497, or otherwise known as the Civil Aviation Authority Act of 2008, and ships. Okay? Interest in sea vessels or ships, subject to Presidential Decree number 1521 or the Ship Mortgage Decree of 1978. So principally, you have this general rule that all transactions of any form that secures an obligation with movable collateral is covered. Okay? So all transactions. And there are only two exceptions again: aircrafts and ships. Okay? While you may ask basically, why those two exceptions in terms of the general rule? These two exceptions are, of course, okay, while they may be considered or while they may be covered as by some to be movable collateral, these are all subject to other interests as well. And these other interests as well and the facts and circumstances are already stated in their corresponding special laws. Okay? So those special laws will be principally the Civil Aviation Authority Act of 1978 and the Ship Mortgage Decree of 1978. Okay? So again, note the
Villasis Law
general
Center.
rule, all transactions of any form. Okay? Two exceptions: aircrafts and vessels. So I hope you're still continuing to learn from this session on special discourse on special commercial laws. Kindly type VLC. Thank you. Okay, now, before we move on, I would like to ask everyone in this session now a question. And you may type this in the chat box or uh, provided in the space. Okay? Do you agree that the PPSA will eventually help micro, small, and medium enterprises to have access to credit facilities? Based on the principal summary that I've outlined for you now, do you agree that the Personal Property Security Act will really help micro, small, and medium enterprises have access to credit facilities. So again, you may type your answer in the chat box provided. Okay. Moving forward, so the question will be now be how do you create security interests over personal property or movable collateral? These are all stated in Republic Act 1057. And in your screen right now, I've outlined and made a comparison between how you create security interests, okay, as stated in Section 5, and how it is clearly stated as well in Section 3.01 of the IRR. So principally, based on the Personal Property Security Act, security interest is created by a security agreement. Okay, so the contract that will be basically executed by the parties is referred to as a security agreement. Now, and this I've outlined as well, stated a few minutes ago. A security agreement may cover as well future property. Okay, now compare this already with what is provided as well in the screen. And you may refer to Section 3.01 of the IRR. A security interest shall be created by a security agreement or the lease of an operating lease not less than 1 year. So please note the clarifications as well in terms of how the security interest is created as provided in the implementing rules and regulations as well. Now, please note and the second sentence as well, the implementing rules and regulations with respect to the sale of an account receivable. Note the quality proviso as well, unless otherwise stipulated by all the parties in the document or sale. Moving on. Okay. So that particular section discusses for you the coverage of future property. Now let me move forward in terms of the applicable provisions of the Personal Property Security Act and the implementing rules and regulations on future property. Okay. Now, proper reference still is on Section 5 of the law. Okay? But note Section 3.05 of the implementing rules and regulations as shown on your screen. Okay? Here, in terms of the implementing rules and regulations, you may find basically reference to the type of property involved. Okay? Now, please note that these are all outlined in the second and third paragraph of the implementing rules and regulations in reference to tangible asset, okay, and including to the extension of the tangible asset as well. Okay? So, the expansion of the implementing rules and regulations was basically contextualized as well to ensure continuity of the security interest over future property. But please note again, okay, in terms of the future property, there is a limitation, okay, as provided in Section 5 and as provided in Section 3.05. Where will you find that limitation? In the law itself, you may find that in subparagraph B. Okay? In the IRR, you will see that in the first paragraph of Section 3.05. Okay? The grantor, okay, the security interest in the property is created only when the grantor acquires its right or the power to uncover it. Now, that means while you may agree on future property, it is subject
Villasis Law
to
Center.
those general guidelines as well. Okay? So if it does not qualify with respect to the guidelines, then the security interest over the future property cannot be considered as valid. Now, as we said, there is a formal requirement already in terms of how do you now create a security interest over movable collateral. Okay? And that document, which I said a while ago, is referred to as the security agreement. And if you will read Section 6 of the Republic Act in terms of the formal requirements, okay, proper reference in the IRR can be made also to Section 3.03 as with respect to the form. Now, what is the importance of the form? Okay? The importance of the forms comes in the fact that there is a notice requirement to be registered with in the central registry being maintained by the LRA. So, form is an essential requirement in terms of the validity of the security agreement. Now, in reference to section 3.03, and may I draw your attention to the second sentence of the first paragraph, it may consist of one, okay, or more writings that taken together establish the intent of the parties. Okay? So there may be several security agreements constituted over, okay, the property that is the subject of the agreement between the parties. But then again, in terms of its consideration, it can be taken together. Okay? And may I draw your attention again to the first sentence of section 3.03 of the IRR. Okay? It is a written contract and it must be able to identify the collateral of the secured obligation. Why? Again, please remember the fact that there is a requirement of notice and there is a requirement of registration in the central registry. Okay? Now, what is the language? Even the language was already considered as well in terms of the second paragraph of section 6 and the second paragraph of section 3.0. Okay? It shall have it may be in a language agreed to by the parties as well, but the grantor shall have the right option to have the agreement and notices in Filipino. So again, this is to facilitate and ensure that there is proper consent made by the parties in the execution of that security contract or agreement. Okay? Now, how should the property be described? Because in our earlier discussion, again, you will notice that there is a requirement under the IRR on the description of the property. So what or how should the property be described based on law and the IRR? Okay? So again, note the applicable provision of Section 7 and reference thereto. You may also you should consider Section 3.04 with respect to the description of the collateral. So how should it be described? It should be considered sufficient if it reasonably identifies the collateral. And a specific description of the property as collateral is not required in constituting the security interest. Okay? So, note the last sentence of the IRR, section 3.04. A description such as all personal property, all equipment, all inventory, or all personal property within that generic category, okay, shall already be considered sufficient. Okay? So description, while required, okay, there are considered to be general considerations as well on how that description should be done. Okay? So the general description is allowed based on the requirement on form. Okay? So, like a friend or host, watch party while watching this video. Okay, now, since the Personal Property Security Act expanded the movable collateral to include deposits, okay, as well, and other
Villasis
personal
Law Center.
property, there may be a situation that there may be commingling of funds and money. So, that recognition of that fact was properly acknowledged when the PPSA law was drafted. So please note, there are specific rules on the rights to proceeds and commingled funds as well. And one of that principal consideration is stated in subparagraph A of section 8 of the law. A security interest in personal property shall extend to its identifiable or traceable properties. Okay? So, traceable proceeds of the properties is covered by the security interest as well. Okay. Now, why is that being done? And that again is consistent with the general principle that it must ensure continuity of security interests. Okay? So in terms of how that continuity shall be enforced, note the provisions of Section 9 of the law and Sections 3.02 of the implementing rules and regulations as reflected on your screen right now. Okay? And proper reference as well must be made to Section 21 in terms of a rather what has been referred to as transferee exceptions on the on the principle that you should ensure continuity of the security interests. Now, as in any security agreement, okay, we've identified the scope, we've identified exceptions to that scope. There are also limitations on the creation of security interests. Right? But those limitations are considered to be contractual limitations as well. Okay? So in terms of what would be the contractual limitations shown on your screen right now are the pertinent provisions of the law and the IRR. Okay? So uh, it will all depend basically. Okay? Consider Section 10 of Republic Act 110557. Proper reference still will be made in terms of what is the property involved in. Okay? So in subparagraph A of section 10, you will see here reference to an account receivable. Okay? So please consider those particular provisions with respect to any question if there are limitations on the creation of security interest over movable. Okay. Now, a security contract is a security agreement is considered to be a contract. So there must be consent, object, and consideration. Now, when will you consider that contract to be perfected already? Okay? There are specific rules as well set by the law and set by the IRR. So please note in terms of being asked a question on when will the security contract or agreement executed by the parties be considered already as perfected. Okay? Subparagraph A of Section 11 provides that the security interest shall be perfected when it has been created, and the secured creditor has taken one of the actions in accordance with the provisions of Section 12. Now, subparagraph B is consistent with the first paragraph of Section 12.01. It becomes effective against third parties. Okay? So, on perfection, the principal effect, okay, it will not just bind the parties, but it will already be considered as effective as well against third parties. Okay? Now, with perfection, with the rules of perfection clearly stated, what will now be the means of perfection? The means of perfection will be basically principally based on what is the type of property or asset involved. Okay? So please consider the type of property because the type of property, okay, there are different rules with respect to how perfection should be construed as done. Okay? So please note, while it is not clearly stated in section 12, with respect to how these properties are considered or the means of
Villasis
its
Law Center.
perfection, proper reference as well. And I made reference, and clearly this is stated in the IRR on the different types of property involved as well. So please consider first the means of the question of means of perfection. Please consider this and ask yourself, what is the property or asset involved? Is it tangible, intangible? Okay? So before you consider the means of its perfection. So please go back to sections 12, and I've outlined as well for you the 2019 applicable provisions of the IR with respect to the different kinds of asset involved in the perfection of that security contract. All right. Now, another aspect of the control or the means of perfection of the Security Act contract is the Section 13, the means of control. Okay? And this again will involve a determination of what is the proper fee. Okay? So please consider subparagraph A as an example of Section 13. A security interest in a deposit account or investment property may be perfected by control through the actual creation of a security interest in favor of the deposit-taking institution or the conclusion of a control agreement. Okay? Okay. So again, with respect to perfection, please consider the type of property involved. Now, the law also recognizes that there can be changes in terms of the means of perfection. Okay? Note section 15 and 16 in terms of how this will be done and what are the requirements as well. Okay? Now, in terms of the IRR, proper reference as well can be made to sections 4.08 and 4.09. Okay? So, there can be changes, okay, in the means of perfection. That is allowed by law. But given that allowance given already as well, please consider that there are also limitations and requirements in terms of the changes to be made in the security perfection of the security contract. Okay, now remember the requirement of notice and the requirement of registration in the central registry. These are all meant basically to ensure that there is priority in the security interest as well. Okay. Now, please note, Section 17. There are specific rules in terms of the priority in the security interest. Okay. So, it's basically based according to time and on registration for notice or perfection. Okay. So, it's basically who registers first, and priority shall be determined based on that. Okay? So it is not with regards to order of creation to determine priority. Okay? It is with respect to the registration and notice requirement of the PPSA that is important. Okay? So this again, and it's an illustration. So again, with the description of the collateral, note section 7. Okay. There can be a general description of the collateral, as amply stated as well in section 3.04 of the implementing rules and regulations adopted in November 2008. Okay. So if you have any reaction that you would like to address, you may leave it in the comment page of this page as well. Okay. This we've covered already. And before we move forward to the other significant laws covered by this discourse, okay, let me ask a question. And this you may type in your the comment page, the comment part of the page. Okay? Let me ask a question. Okay? What are your significant learnings so far about the Personal Property Security Act and its implementing rules and regulations? So again, given what we've stated, given what we've discussed in this conversation, okay, what do you consider to be your significant learnings about the Personal Property Security Act and the coverage under the implementing rules and regulations? So you may type your comment and your response to the question, okay, in the chat box of the page. Okay? So I hope you're learning as well. Please just type PLC in the comment page as well. Okay, now let me move forward, okay, to a summary of jurisprudence and other issuances and special commercial laws that you may properly consider as well in your review. So in terms of the summary, I will not be going already to the main provisions of the following special commercial laws. What I did basically is to highlight what are deemed what I deem to be significant, okay, in terms of the development on uh, laws like the foreign investment law, okay, insolvency laws, particularly on the Financial Rehabilitation and Insolvency Act. Okay? And then I will also consider as well a significant matter pertaining to the Philippine Competition Law. And it's how reviews on mergers and acquisitions are actually being done, okay? And what are the remedies of the Philippine Competition Commission in terms of enforcement of the competition law and its implementing rules and regulations as well. Okay. Now, for the past bar exams, there have been questions raised covering the Foreign Investments Act. So the usual questions with respect to the Foreign Investments Act are who are considered to be doing business in the Philippines. Now, there may be questions as well with respect to the negative list, and which we all know to be there are two lists under the foreign that aspect. Okay? There's a negative list A and there's a negative list B. Okay? Now, a basic principle, however, in terms of understanding the foreign investment law is asking ourselves, why was it passed? Okay? What is the nature of the foreign investments law? So that question has been answered in the case of heirs of Winston Gamboa versus Margarito Teves, okay, in 2012, where the Supreme Court noted that the Foreign Investments Act is the basic law governing foreign investments in the Philippines. Now, the Supreme Court also said that given that it is the basic law, okay, it is irrespective of the nature of business and the area of investment. Okay? So the procedures are also spelled out in the Foreign Investments Act. But proper reference, and this we will know as well, okay, depending on the type of business and also where did they establish their business. Okay? Now, the Foreign Investment Act, like its earlier predecessor, statutorily clearly defines as well for us who is a Filipino national. Now, this is important, right? Because aside from the requirements under the Corporation Code, right, there is a nationality requirement as well under the Foreign Investments Act. Okay? And the nationality requirement is important to determine whether or not this particular individual or a corporate entity can legally engage in the or doing business in the Philippines as well. Okay, so that nationality requirement is already clearly stated as well under and required under the Constitution. Okay? In the Foreign Investment Act as well, considered already the constitutional framework on the nationality requirement. Okay? Okay. Now, the usual questions in respect to the Foreign Investments Act will be on the matter pertaining to doing business. Now, the classic case in reference to answer this question, of course, will be the Steel case, as promulgated by the Supreme Court in 2012. So the Steel case jurisprudence discussed and defined for us doing business in the Philippines in the context of the Foreign Investments Act. The Supreme Court also,
Villasis
in
Law
that same
Center.
case, covered a discussion on who are not considered doing business in the Philippines. Okay? So please remember this is very important jurisprudence in terms of answering the question on who are considered to be doing business in the Philippines. There is a quite an there is already an enumeration made by the Supreme Court with respect to answering this question. Okay. Now, Steel case basically pointed out as well for us that the appointment of a distributor in the Philippines is not sufficient to constitute doing business. Now, why is the importance of doing business necessary in terms of determining whether or not the applicable provisions of the Foreign Investments Act may be invoked? Tax purposes as well. Okay? Now, please note as well that while the appointment of distributor is considered not to be is not sufficient to constitute determination of whether you are doing business. Okay? The Supreme Court also said in that same case, okay, it can, if the distributor is an independent entity which buys and distributes products rather than those other than those of the foreign corporation, for in its own name and for its own account, then okay, it can not be considered to be doing business in the Philippines still. So the Supreme Court as well in that case made ruling that a factual determination on whether or not this establishment is considered to be doing business shall be in a case-to-case basis or based on the attendant circumstances of the case as well. Okay, now one important rule with respect to doing business is the case promulgated, the ponente was Justice Conen, in the case of Commissioner of Internal Revenue versus J.P. Morgan Chase Bank. Okay? Justice Conen in the 2018 case said that PEZA granted incentives shall only apply to registered operations of the Ecozone enterprise and only during its registration with PEZA. So clearly this is a limitation on the availment of the incentives by the foreign investor. Okay? So again, the incentives shall apply only to the registered operations of the Ecozone enterprise and only during its registration. Losing these qualifications means it cannot anymore avail of its incentives provided under the PEZA law, okay, and in the reference as well to the Foreign Investments Act. Okay, so what happened in this case? The Supreme Court said that the act of leasing the physical plant space, infrastructure, and other transmission facilities of a PEZA registered export enterprise is not covered within the registered activities. Okay? Therefore, the income derived from those activities shall be subject to the proper tax as well. Okay, so again, remember the case where the ponente was Justice Yonen in terms of the limitation and availment of these incentives, okay, as issued in November 2018. Okay, now let me move forward now to the Financial Rehabilitation and Insolvency Act. So before I move forward, I hope you're still watching this and continuing to learn from our discussions. Please type VLC in terms of asking ourselves and knowing from our end, okay, if you're enjoying and learning from these sessions. So let me move forward to the FRIA law. Okay, note the 2019 of Las Savery Developing Corporation versus Buenasita Properties, okay, where the Supreme Court defined again for us rehabilitation. Because remember, okay, rehabilitation under the FRIA law is not the same as rehabilitation under the old insolvency and bankruptcy laws already. And the Supreme Court, in the case of La Savoie, defined for us rehabilitation in the context of FRIA. So how did the Supreme Court define for us rehabilitation? Okay. Rehabilitation was defined as the restoration of a debtor to a condition of
Villasis Law
successful
Center.
operation and solvency, if it is shown that its continuance of operation is economically feasible and the creditors can recover by way of present value payments projected in the plan. Okay? So rehabilitation should be understood in the context of ensuring, again, being able to go back to a successful operation in order for the rehabilitation, the establishment undergoing rehabilitation to be able to pay back its creditors. Okay, so it's not closure. Rehabilitation is in the context of restoration of the debtor to condition of successful operation and solvency. Okay, Now, corporate rehabilitation as well was defined in that same case. Corporate rehabilitation is defined by the Supreme Court is an effort to restore and reinstate the corporation to its former position of successful operation and solvency. Sorry. So again, the context is to ensure that the corporation will be able to go back to paying its creditors as well. So context of rehabilitation is restoration to successful operation and solvency. Now, with the current public health situation right now, there are a number of companies that are being closed. But principal remedies are also provided by the Financial Rehabilitation and Solvency Act to address these concerns. Okay? So it can be basically um, done in court or outside of court by the parties. But again, right, FRIA encourages parties, individuals, corporations to avail of the remedies provided therein, to undergo rehabilitation. Okay? Now, note the limitation as well that the FRIA will not be applicable to banks or quasi-banks, insurance companies, and pre-need companies because they are all governed by general special laws with respect to their rehabilitation as well. Okay? So again, there are three principal modes of rehabilitation. You have court supervised, you have pre-negotiated rehabilitation, and through out of court or informal proceedings. Now, with respect to court supervised, right, what is important there is the determination of when the commencement order was issued. So in terms of determination of the commencement order, the value of the commencement order, and when the rehabilitation proceedings should actually be considered as having started with the issuance of the commencement order, please refer to sections 15 and 16 of the Free Law. Now, I outlined significant portions, and this is shown in the screen. Section 16, with respect to the contents of the commencement order. Please remember the contents of the commencement order because this establishes basically the substantial requirements on what should be in the commencement order that would ensure rehabilitation of the entity involved. Okay. Now, pre-negotiated rehabilitation, as the term implies, can be done by the debtor by himself or jointly with creditors. There is a specific threshold requirement in terms of the creditors. So please note the two-thirds requirement in terms of the total liabilities of the debtor. So two-thirds of the universe. Okay, and we need to make a distinction based on those creditors, whether they are secured creditors or they are unsecured creditors as well. Okay? Because there is a different threshold. While it's 50-50%, the base of determining that 50% is on the declarations made as well by the creditor on who are his debtors. Okay? Now, out of court settlement, it's basically clear as well. Court assistance in order to achieve the objectives of rehabilitation. And there are minimum requirements set by law as well with respect to how this remedy can be exercised. So, shown on your screen right now are the distinctions of the different remedies. Okay, so note as well the threshold requirements required under the law. Okay. I hope you are still continuing to learn
Villasis
from
Law
this
Center.
session, and you may type your comments below in the chat box as well. Now, before we move forward to the last particular special law that I would be discussing, I would like to pose this question again, and you may type this in the chat box. Okay? Given today's public health situation and economic crisis, knowing what you all have already regarding Financial and Rehabilitation Act, would you advise businesses to avail of the remedies still under the FRIA law? Okay, so you may type and share with us your answer to this question in the chat box. Now let me move forward to the last law that I will be discussing. Okay? This is with respect to the Philippine competition law. Let me provide first the context of the competition law. It is considered to be the antitrust law of the Philippines. Prior to the enactment of Republic Act 10667, there is legally no trust antitrust law. Now, with the passage of the competition law, okay, there was a creation of the Philippine Competition Commission, which will review mergers and acquisitions of parties. Okay, and aside from that mandate, there are also considerations with respect to ensuring the objective that the market remains to be competitive and open to everyone, and that it is considered to be a violation of the antitrust law should you fail to do so. Now, this is again a short statement on what is the objective of the competition law. This is basically meant to ensure the well-being of consumers and to preserve the efficiency of competition in the marketplace. Okay, so this is basically the principal objectives of the competition law, and those objectives are clearly stated in the whole reading of the law itself. Now, I would like to talk about the uh, interim measures order being issued by the Philippine Competition Commission. What is the value of this interim measures order? Okay. The interim measures order basically says that why, okay, we are reviewing your merger and acquisition, okay, you must exercise or do these interim measures as well already. Okay? Why? Because the Philippine competition may later on make a declaration that there is a violation of the rules on merger and acquisition, or that this particular agreement signed by the parties is really violates the antitrust law. Okay? Now, the interim measures order, okay, interim measures order, okay, are basically meant to ensure as well that there will be no violation of the competition law, and that you are prohibited as well from consummating the agreement until after the commission has already given its clearance to the proposed merger or acquisition, for example. Okay? Now, the interim measures order, okay, proper legal basis is section 12, subparagraph F. Okay? So the interim measures order can include not just the imposition of fines, but also interim orders and such as a show cause and an order and cease and desist issued against the private person. Okay, this is also consistent with the PCC rules on merger procedures. So, particular reference to the implementing rules and regulations is section 2.13, subparagraph G. Okay, so what is this important? Because you may be liable for fines for violation of these requirements. Okay, so section 29, subparagraph B lays the basis already for the imposition of fines. Okay, now let me talk about a particular case. Okay, that would allow for the issuance that basically allow the PCC to issue the interim measures order. Okay? And this was clearly amplified in the case of Uber and Grab. Okay? Both
Villasis Law Center
are public utility companies, okay? But issues have been raised against them as well. When this proposal okay, was first considered by the Philippine Competition Commission, the question was, can their merger or acquisition, okay, amount to no competition to the marketplace? Okay, so can there be a monopoly already as well in terms of that proposed merger? Okay, so how did the Supreme Court determine for us how this should be properly done? Okay, there were fines involved. The Philippine Competition imposed fines on both Uber and Grab for violation of the interim measures order that they issued. Okay? the Philippine Competition Commission said that while we are transitioning to the merger and acquisition, your interim measures that you have submitted to the Securities and Exchange Commission, okay, should be properly enforced. Failure to comply with the interim measures order would mean already, okay, that you have already will be subject to the proper fines and penalties as well. So in the case of Uber and Grab, okay, they were all fined 4 million pesos. But on the part of Grab, in addition, he was fined another 8 million pesos. So Uber, as the acquired party, right, was also fined 4 million as well on behalf of Grab's violations. Okay. Now, to ensure that there can be proper preservation of whatever the properties involved in, okay, the interim measures were meant to protect the interests of the consumer and meant as well to protect the interests of the uh, owner. Okay, so these are examples and cited on your screen are the interim measures order uh, issued to both Uber and Grab, right, in terms of the proposed merger or acquisition. Okay. Okay. So, given the powers of the Philippine Competition Commission to issue interim measures order, let me ask this question again. Okay? Do you agree with the power of the PCC to issue interim measures order? Given the current public health situation, for example, if the PCC says that this there must be continuity, okay, in terms of the proposed merger and acquisition, uh, which the parties have agreed to. Okay? Is this not already an indication that we are already encroaching on the business decision of the corporations or their respective stockholders and board of directors? Okay? Will the interim measure order actually defeat the purpose of ensuring that there is competition in the marketplace? The answer to the question, you may answer it in the chat box provided. So, thank you for watching and for staying with us for the past hour. Please visit the VLC website at www.villasislawcenter.com to know more about the virtual law companion. Prepare for the bar examinations at any time, anywhere, and from any mobile device of your choice. And together, we can. Thank you, everyone.
The law firm of Villasis and Partners, VP Law, is a law office engaged in the general practice of law. Its principal office is conveniently located at the heart of the University Belt at Villasis Law Center, VLC, Unit 911 CKKFI Building P. Paredes Street, Sampaloc, Manila. VP Law was organized in 2015 by attorney Christian G. Villasis and continues to expand to date. From the start, VP Law has maintained a varied and prestigious client base and continues to be recognized as one of the leading law firms in the country. VP Law has a diversified general law practice as the firm handles all aspects of corporate, commercial and business transactions, protection and enforcement of intellectual property rights and data privacy rights, collection, civil and criminal litigation, admiralty and maritime practice, labor management relations, election, administrative and local government cases, real estate transactions, land titles, deeds and conveyances, foreclosure of mortgages, writ of possession, replevin, bought laws, business organizations and corporate regulatory compliance and taxation, among others. In addition, the firm offers contract drafting, review, and negotiation, legal research and consultation, as well as other legal assistance appurtenant thereto. At present, the firm's increasing number of lawyers is capable of handling various legal matters and cases and is able and willing to cater to clients' concerns with utmost professionalism and zeal. Apart from experienced VP law lawyers, its legal team includes highly competent paralegals and professional legal staff who are constantly inclined to assist the lawyers, thereby ensuring efficient and cost-effective service to its clients. VP Law aims to provide its clients with quality legal representation anchored on the ethics of hard work, commitment and responsiveness to clients' needs. This vision has been the moving force in the firm's growth into a first-rate, full-service law firm.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate.
In Spouses Minjola British Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tingnan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised?
The next one is with respect to estate, alright? Gifts, alright? Bequest devices. If you try to analyze it, these are actually the transfer taxes being pertained to in the National Internal Revenue Code. They are the estate for inheritance or succession, and then the donor's tax for gifts, right? So one is mortis causa, that's the estate tax, and the other one is inter vivos. Now, incidentally, I just got reminded that, you learned in the general principles of taxation that the main purpose of taxation is actually to raise revenue. But in the case of donor's tax, it's not actually the main purpose, although it's still one of the purposes of donor's tax. But primarily, donor's tax is actually, alright,
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between 2 persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Rule 30 is trial in civil cases, while Rule 119 is trial in criminal cases. Under Rule 119, trial in criminal cases, I give emphasis to the following issues. The first is the continuous trial, which I've already partly discussed with you. Just refer yourselves to the continuous trial rule in criminal cases, the latest on the issue. Then the second issue that I would like to discuss in Rule 119 would be the mode of discovery, which should be discussed in relation to Rule 23 of
answer either way, class, and so long as you're able to present in your answer basic precepts, sound ones and rational ones, then it should be your answer given full credit. It would all depend on, as I always announce in my classes, it would always depend on your English. All right. You say that the successor president can act on those bills. Why? Well, because the Constitution does not make any distinction as to the rule of presentment and the competence of either predecessor or successor president to approve or veto the same. The only prescription in the Constitution is that if it were not acted within 30 days, then it shall be considered essentially as having lapsed into law. But you can answer that way, class, and that should be a correct answer. But then you can answer the argument.
So, importante, again, sequential, you may skip, but make sure that you are still on that track. And what best way for you to make sure that you are still on track is, again, to devote a page to a main question. Make sure that you do this so that you wouldn't be forced to resort to putting notes like how you do it in law school, because in the bar examinations, no more. Di ba yung notes mo dun sa examiner, Mr. Bar Examiner, please check the last page of my note of my booklet, because that's where I put my answer to this question. That's not allowed anymore because that's an unnecessary marking, right? So, kung sa law school, nagagawa yun dati, puro arrows, you try to direct your professor on where to use.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like, for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or, for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand, and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the purpose.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.